Catherine Amirfar.
And I'm Cal Raustiala.
And this is International Law Behind the Headlines, coming to you from
the American Society of International Law.
Hello, everyone, and welcome back to another episode of International Law Behind the Headlines. I'm Cal Raustiala, and happy to be hosting today and to have as our guest Duncan Hollis. Duncan teaches at Temple Law School, is probably known to many listeners. Here, he is a treaty expert, the editor of the Oxford Guide to Treaties, which I'm pretty sure I have a chapter in. Is that right, Duncan? Am I remembering?
You do. You're the expert on non-governmental organization participation in treaties.
Yes.
So, yeah.
Fantastic book, of course. And I've invited Duncan on to talk about the U.S.-Iran MOU, or sometimes referred to as the Islamabad MOU, which we're recording this on July 13th. At this particular moment, that MOU is in a maybe moribund state. I guess we can get into this question of what the status of this even is. But really what we wanted to have Duncan on for was to discuss what kind of agreement is this? Is this a treaty? Is it not a treaty? Why does it matter? And ancillary questions related to that. So, Duncan, welcome to the podcast.
Oh, thanks, Cal. Thanks for having me.
Great to have you on. So let's start with that issue. So this MOU, 14 points, kind of an interesting number. There's been some discussion about how to think about this, and we might even hark back to the 2015 JCPOA. There was some discussion there too about the nature of that agreement. But let's start with the 2026 version. Is it a treaty in your view?
So I think the verdict is still out now, several weeks on since its conclusion, right? I certainly think the United States, if I'm guessing, did not think that they were making a treaty. But I am also kind of quite, I don't want to say sure, but I suspect that the Iranians thought they were. So I fear that what we have here is misaligned intentions. And you can see that in the text itself with kind of contrasting signals, some of which suggest that the parties thought they were doing a binding agreement and other signals that cut the other way. So I don't know that it's an easy answer because we decide if something's a treaty or not by looking, of course, at the text, but also at the surrounding circumstances and subsequent practice. So, maybe if both sides were able to kind of come out and clearly put a thumb on one side of the scale or the other, we'd have that question resolved. But as of right now, I think the answer is quite murky.
Great. Let's get into that a little bit and break that down. Let me just start with the kind of meta question. So you sort of alluded in a sense to the interpretive question of how we might look at the question of, is this a treaty or not? Or for that matter, any agreement, whether it's a treaty or not. Would we use the traditional interpretive principles in the Vienna Convention on the Law of Treaties to decide the question of whether an agreement is a treaty?
That's a great question. I don't think it's resolved. I think a lot of people would assume that that's an approach to go. And certainly one of the advantages of the Vienna Convention on the Law of Treaties, treaty interpretation rules, is its flexibility, right? It allows you to prioritize without necessarily a fixed hierarchy of text, object and purpose, as well as the so-called travaux préparatoires, that is kind of the legislative history of the agreement, plus subsequent agreements, plus subsequent practice. All of those can filter in. So in one way, we could say, we're just applying the VCLT, the Vienna Convention on the Law of Treaties, to decide if something's a treaty or not. That said, I do think that states and scholars over the years have kind of come up with a more kind of fixed focus of a certain set of textual cues that point in one direction or another without any sort of magic word approach. I don't think there's some magic word you use that says, it's a treaty or it's not a treaty, but kind of that the context of the words being used, the surrounding circumstances at the time the agreement's concluded, and of course what the parties say subsequently. That, I think, is the methodology that's probably dominant for most foreign ministry lawyers that look to these sorts of issues.
Great. So expand upon that a little bit. What are some of the, maybe not magic words, but some of the indicators that one might look for to determine this question?
So I think let's start off with the title itself, because, we have here something called a Memorandum of Understanding. And certainly there have been in the past some suggestions that, particularly by the British, they had a famous lawyer, Tony Aust, who's since passed, who kind of used to say, if we call it an MOU, the United Kingdom view is it's non-binding. That's not been the U.S. perspective. Frankly, the U.S. has a number of MOUs that it considers to be binding treaties governed by international law, but also other MOUs that it considers to just be so-called political commitments or not legally binding. Now, I emphasize this because there was a kind of infamous exchange during the first Trump administration where Trump and his USTR, Robert Lighthizer, got into a fairly public spat in front of the TV cameras on this question. And Lighthizer was trying to explain the U.S. practices don't rely on the title MOU to decide if something's binding or not. And Trump just pushed back and said, no, if it's an MOU, it's not binding. Now, he's wrong, I think, internationally on that, but it probably stemmed from his own experience as a real estate or commercial practitioner in the past. So I do think, like, first and foremost, one would think that if the U.S. used the title MOU here under the Trump administration, they probably thought it was not binding. But then you also have to look at the text. Now, sometimes it's easy. If the states say, we shall or we must do something, that tends to suggest objectively an intention to be bound under international law, or at least under law. And if they say should, hoping, wishing, intending, planning to, those are more indicative of a non-binding intent. Here, we don't have shells or shoulds. We have wills. And here again, I think there's a mixed history of whether will is just a statement of future intent without any present intent to be bound. But for others, will could be the equivalent of shall. Similarly, you see language in this about agreement. And the U.S. practice there has been pretty strident that if the words agree appear in the text, that will be a strong indicator of something being legally binding. And I could go on, but you for treaty lawyers, you actually do kind of parse through the text and look for these sort of indicia that put you on one side or the line or the other, as it were.
Great, very helpful. Two things. One, it's funny what you said about Tony Oust. I feel like I've heard that, but I also recall pretty clearly in his book, which is fantastic on treaty matters. I'm now forgetting the title of that book, but he does at one point specifically say something to the effect of titles don't matter, and he lists a bunch of different ways that you might name a treaty, and all of them in his view in that book are sort of irrelevant, whether you call it convention or agreement or whatever. So it's interesting that MOU is somehow struck out from that list, or that principle that titles don't matter. But maybe I'm misremembering. The second thing is what you were just saying about shall and should. As I recall, with the Paris Accord, there was debate over this issue of using should and shall, and the U.S. fought for should in one situation. And it just raises a question about whether this is a agreement by agreement question or a commitment by commitment question. In other words, could there be an agreement that has some commitments in a shall form, in a binding form, but the overall agreement isn't? Is that possible conceptually? How do you approach that?
Sure. Well, let me back up. So first of all, shout out to Tony Aust's book, which now Jeremy Hill has, I think, in a 4th edition, Modern Treaty Law and Practice. And I do think you're right that he says, in general, titles are not determinative, but then goes on, or at least when he was still with us, went on at length to explain the British practice, though, was to treat MOUs and only use that title for non-binding. So it's kind of like, that he kind of carved that out as a special one, whereas if you said convention, treaty, international agreement, minutes, all of those were not necessarily going to be have the signaling function that an MOU might. The Paris Agreement, I think, is interesting. You're absolutely right. As I understand it, from some of the folks that were involved with Secretary of State John Kerry, they were up to the wire on concluding that, and someone took the French text and basically turned the version of shall into should, and then it was going to be translated in English accordingly. And the U.S. lawyers went to the Secretary of State and said, "You can't sign this. If you sign this, it really materially changes the kind of the core commitment from something where states could at their discretion indicate what their national contribution to reducing greenhouse gas emissions would be versus a mandated, like whatever you promise you would have to follow through on." And so they ended up kind of basically saying the U.S. will not sign until the shall goes back to should. Now, to your question, though, I don't think that move from shall to should turned the Paris Agreement into a non-legally binding agreement. It just turned that provision into something that was non-legally binding. And indeed, we have plenty of examples of treaties that are mixed, right? Where there'll be certain commitments, like the Paris Agreement. There's a treaty commitment to file certain reports, to meet certain times of the year or at a certain kind of cadence, even if there's no legally binding commitment to have a national contribution at some fixed threshold. So overall, the Paris Agreement is a treaty, even if it contains non-binding agreements. You saw that similarly when we had a treaty of amity with Iran, 1951 Treaty of Peace and Amity. The U.S. and Iran, like Article 1, the ICJ basically said wasn't necessarily legally binding, even as other articles of that treaty were. So certainly you can have a treaty that contains non-binding provisions. I think the idea of a non-legally binding agreement is that it, though, has to be non-legally binding in all respects. Like
across the board.
Once you have a provision that's legally binding, I think it turns the whole thing into a treaty, even if, say, 9 out of the 10 articles aren't binding. That one article brings you into the treaty ambit and brings with it all of the law of treaties to apply.
That's interesting. Yeah, I'm not sure where I personally come down on that question, but I think that's right. That the way you're comparing the two versions strikes me as conceptually sound. Let's turn back to the current Iran agreement. So using that framework, let's say we decided that one of the commitments of the 14 paragraphs was in fact binding, then that would turn it into a treaty using your framework.
Yep. Yeah. And so I think, like, you take a look, right, at the first paragraph of the MOU, right? The U.S. and Iran, together with their allies, let's bracket the allies for a moment, declare upon the signing of this MOU that there will be an immediate and permanent end to the war on all fronts. And then they undertake, and in international parlance, undertake is a verb that tends to be more like a shall than a should. They won't launch any hostile actions against each other. Now, we've seen a lot of hostile actions in the last week or so I'm not sure there's compliance with that paragraph right now. But, just looking at that first paragraph alone, there's a lot of signals that might suggest a legal commitment there.
And the signature element, does that have any bearing?
So, I think signature and like a signing ceremony certainly can be evidence of the formality that push you in the direction of a treaty. But here, for example, the International Court of Justice in like the Pulp Mills case and others has found that a treaty can exist even in a joint press release, right, that wasn't signed. So signature alone, in the same way, say that the title alone is not going to be determinative, right? Like just because you signed it doesn't make it a treaty. And conversely, just because you don't sign it doesn't mean that you're outside of the treaty ambit.
Great. Super helpful. So coming back to the issue of maybe a difference in opinion between Iran and the U.S., I feel like this might have also been the case with the JCPOA, that there was some debate between Iran and the U.S. about how it was presented. But either way, with the current agreement, or any agreement, if there are two parties, if it's bilateral, and one party believes it's a treaty and the other believes it is not, is one wrong, or can there in fact be a difference depending on who the party is?
So I think it's tricky, right? Like in an ideal world, this would be an interpretive dispute or a dispute under international law. And certainly it's been the sort of question that has ended up before international tribunals in other contexts, right? And there you would allow the court to say, oh, yes, this was binding, or this wasn't binding, or there was an agreement here, or there was no agreement here. Obviously, that's not going to happen in this particular instance. The other option is the two kind of come to some sort of arrangement once they realize they have a difference of opinion. And this actually famously happened between the U.S., the United Kingdom, and Canada in the 1980s. Under a U.S. statute, the U.S. could do information and exchange agreements on defense and other intelligence matters with certain allies, including the UK and Canada. But the congressional statute that authorized these made it clear that they had to be legally binding. Meanwhile, the British and the Canadians were using titles like MOU and verbs like will, and were left with the impression after these agreements were concluded that they were non-binding. And, after a couple of years, it surfaces, right, that one side thought it was a treaty and, the U.S. UK, the U.S. Canada, the other side thought that they were not. And the two parties basically then went back to the negotiating table and ended up doing a binding treaty that met all of the parties or all of the, their relevant domestic statutory requirements and legislative procedures and the like, and made it clear that, okay, we now all agree that what follows will be binding. I mean, that certainly could happen here with the U.S. and Iran. I doubt it, though. I mean, I think you're right that the history of the JCPOA suggests what's more likely to happen, as happened there, was the Trump administration walks away from the deal. Iran accuses the U.S. of not having legal authority to walk away, says the U.S. was breached the JCPOA and violated international law. And I wonder if we're not seeing something similar happening here. Although probably at this point, both sides are kind of pointing the finger at the other, saying there's been non-compliance with the MOU. So I think we're left in this kind of, as I said at the outset, a murky area where we have two parties with diametric views of what the deal is. That may be a function of how hastily and haphazardly it was drafted, that we don't have a clear answer. And we also don't have a clear way to resolve who's right and who's wrong.
Terrific. I want to come back to the, let's say, hasty and haphazard. I think that's a pretty fair read of how this was done. But before we do that, what about the possibility of the Security Council anointing this in some way, as was done in the JCPOA, as it's contemplated here? So imagine that there is a Security Council resolution. Somehow we get back on track with the MOU. And the Security Council resolution that then embodies that MOU or some of the key provisions. How does that impact the analysis?
I think, from my perspective, and I should be clear that the doctrine on this is a little bit more sketchy than I'm gonna come across here. I think it's a corrective, right? I think the Security Council may be the one corrective that exists to this sort of disagreement. Because on the one hand, let's assume it's non-binding, right? Like, let's assume the U.S. is right. Under Chapter 7, the Security Council undoubtedly has legal authority acting under Article 41 or 42 if it sees a threat to international peace and security to take a variety of measures. And I think those measures could be to convert something that's non-binding into binding obligations for the U.S., for Iran, and arguably for other member states, right? Which takes care of the problem that is in the MOU right now, where the two signatories purport not to just bind themselves, but to bind others. They suggest that they, in paragraph 14, that the Security Council must or will approve whatever outcome they reach, which, right. I don't think the Security Council has to do that. No. On the other hand, assume it's a treaty, right? Assume that Iran is correct. I think one of the problems under the law of treaties is you have this kind of coercion problem, which is that under the law of treaties, coerced treaties are void ab initio. They're void from the get-go. And there's an argument that the U.S., at least as the first to attack Iran in the spring of 2026, was engaged in armed coercion, and that Iran would be within its rights to not have to comply or treat as void this MOU, let alone any final deal that's reached. And I think that's where the Security Council could be a different kind of corrective, right? Like, again, just like it did with the JCPOA, I think if the Security Council does basically say, here's how we're going to move forward on this, I think it's a way around what otherwise might be a void treaty, an invalid treaty.
Yeah, that's a really interesting point to raise. Just by the way, the exact language, this is point 14, is the final deal in capital for some reason, will be endorsed by a binding UNSC resolution, endorsed. So it's kind of interesting language to use. One, that it's a binding resolution. Two, that it's endorsed. But in any event, you're raising a really important kind of meta point that goes beyond this, is it a treaty or not a treaty question, which is what about coercive agreements generally? And it seems like what you just said is something I agree with, that obviously the Security Council has the ability, the power to make that binding on all states, all member states. But absent that, is there a problem here? So again, it's like a two-stage question. If we assume it's a treaty, but there is no Security Council resolution, as you noted, there's no guarantee of that. You need to get 9 votes. You need to have no vetoes. The U.S. cannot necessarily promise that. So if there is no Security Council resolution, could this be viewed, assuming it is a treaty, as a coercive treaty?
I certainly think so, right? I think, but for, this war of choice by the current administration, we would not be having this agreement. So I do think it's how broad one reads coercion, but, to my mind, there's no question that it was the U.S. that began this particular conflict. And so, it was the U.S. that was, dictating at least, that there needed to be some sort of resolution. And so in that sense, one could see it as coerced. I do recognize some room for disagreement, reasonable disagreement on this. I mean, if you follow at least some reporting, right, there was a suggestion that the U.S. was the one in the end that was desperate to have some sort of resolution, and that the terms are so favorable to Iran that Iran would argue it was not coerced into signing this MOU. If anything, it wanted the deal. I think that's been undercut by recent events, which suggests that Iran is not actually happy with the deal and has insisted at least on a broad interpretation of its ability to control the Straits of Hormuz. And now we have both the U.S. and Iran arguing that there can be tolls on what otherwise international law would allow free navigation over these straits. So, I'm not sure I have a fixed answer for you, but I certainly think that it bears more attention. In the same way that if Ukraine and Russia ever reach a peace deal, I think we're going to have a separate question there about coercion of any final agreement.
Yeah, agreed. You just mentioned an interesting question, which I think I know the answer to, but just to see how you view it, let's imagine that there is a treaty, and that treaty, both parties via that treaty agree to violate international law, perhaps in this case violating the regime governing straits and the passage through those straits. Does that make a difference in any way? I know, and you can sort of break that out into ordinary rules of international law and maybe peremptory rules.
Right. So peremptory rules are what we call jus cogens, right? They're in the law of treaties itself. Just like it says you can't, a coerced treaty is void ab initio. It says the same thing about a treaty that purports to violate peremptory norms or jus cogens. So if this was deemed to be a peremptory norm of international law, the parties, any agreement would be void. The merger of the two examples of this is the Munich Agreement, in 1938, where, you see the division of spheres of influence between the Soviets and the Nazis. And, that's part of why the Vienna Convention on the Law of Treaties is framed the way it is to avoid that sort of emphasis on an ability of states to violate international law. But say it's not a violation of a peremptory norm, I think, I don't think it invalidates the agreement, but it may give rise to state responsibility vis-a-vis all third parties, right? So, anyone who suddenly is finding themselves their international, rights under the law of the sea being impinged upon by this agreement and its implementation by the U.S. and Iran would, I think, have legal standing and a claim to invoke the law of state responsibility and all the remedies that it offers, which may not be as much as domestic law would offer, but it's still something.
Agreed. And is there anything equivalent in the law of treaties to something like the Charming Betsy doctrine in the United States, by which I mean, let's imagine it's not a jus cogens situation, it's simply something like the regime of straits. Is there any kind of interpretive rule or interpretive emphasis we might give to say that if we're interpreting a treaty that purports to violate international law, if there's a construction that allows us to interpret it not to violate international law, we're going to follow that? So I'm sort of paraphrasing the Charming Betsy doctrine there. Is there any version of that internationally?
Yeah, again, I don't know that international lawyers outside the U.S. would say it's an analog to the Charming Betsy canon, right. But under the VCLT, the Vienna Convention on the Law of Treaties, Article 31(3)(c) says you're supposed to interpret a treaty in light of, quote unquote, other relevant rules of international law, right? And so if there's an interpretation, and you're supposed to interpret treaties in good faith, so the presumption there is states in good faith don't intend to violate international law, and we would look to other relevant rules, and that might cabin if there's any interpretive flexibility to push towards a compliant reading of the MOU versus a non-compliant reading.
Terrific. And it's worth noting paragraph 5 of the MOU, in fact, which deals with the question of passage of commercial vessels, charges, all of that through the strait. In fact, at the very end says, in line with applicable international law and the sovereign rights of coastal states of the Strait of Hormuz. So it's a kind of interesting thing to insert in there that maybe belt and suspenders gives a little extra emphasis to some of those principles.
Right.
Let's we're almost done, but let's just wrap up with the question of how the hasty, and I can't remember the phrase you used that I liked.
Hasty and haphazard way
this was done. Is it your sense that the legal advisor's office was deeply involved in the drafting of this?
I would be really surprised if they were, right? I mean, frankly, there are people in the, and I full disclosure, I worked in the treaty office of the State Department, albeit decades ago, but I know there's decades of internal training and thinking on these issues, right? That the U.S. makes textual distinctions between using terms like parties in a treaty and participants in a non-binding, the aforementioned shall, should, avoiding words like agree and agreement. And this does not have any hallmarks of having, strong lawyering. And that's putting aside the fact that, there's also just some really imprecise and strangely worded provisions here that in some ways we might have looked at it as some did 4 weeks ago and said, this isn't going to last, right? There's just too much ambiguity in the instrument, and kind of future conflict was kind of inevitable. Not least of which, as we've already discussed, was purporting to promise to bind third parties through a bilateral MOU does not accord with the law of treaties or international law, right? Like third parties are only bound with their consent in our kind of, foundationally positivist system. And so, to purport to bind allies or to bind the Security Council, to do a $300 billion development fund or the like, I think just doesn't align with the international law that, I'm pretty sure the folks at the State Department know pretty well. And I also think the Iranians have pretty good lawyers on this. And so the question is, to what extent were they involved?
Yeah, no, I agree completely. By the way, parties, as you know, appears once in this MOU, participants never. So I guess that's a slight mark in favor of this being a treaty, but it's again so haphazard that I think you can't really draw much from that. And I agree with your general take that this agreement feels more like an agreement to agree, a term sheet if it were in the business world, something less than a fully fledged agreement, and certainly something that doesn't feel like it got a deep level of scrutiny by the legal advisor's office here or in Iran. But I'm obviously less familiar with what happens in Iran.
Yeah, and interestingly enough, just as the last point is, in the international law doctrine, not necessarily the U.S. practice, which again, I agree is often going to be informed by, people's private commercial backgrounds, an agreement to agree can be a treaty, right? Like it actually in itself can be a treaty, and is usually thought to have legal effect. The legal effect is a good faith obligation to proceed to negotiate the final deal, query whether we have good faith efforts happening right now. Unfortunately, as we record this, I don't think that's the case. Although, again, maybe the participants will circle back and find some way to reassert the relevance of this framework.
Great. Well, terrific. Just to remind listeners, this is July 13th. The agreement is, let's say, in abeyance at the moment. I mean, there's active fighting going on as we record. But I guess my instinct is this agreement will resurface in some way or another soon enough with maybe some changes. But I don't think it's completely dead, but we'll find out. So Duncan, thank you so much. Really hope to have you back on when this issue is live again, as I'm sure it will be. But we really appreciate your input.
No, thanks for having me. It's always great to talk to you.
Terrific.